where I might go for a question, pretty much impossible to challenge, I would go with a trustee time rule. And the time rules are in section 722.23, removal of adolescent offender to family court. This says that after they're arraigned, other than for a violent felony, Class 8 felony other than a drug felony, an offense in the vehicle and traffic law, or one of those bad crimes defined in 1.20.42. So what it says here is that if they're arraigned for a crime, a felony other than those felonies that I just talked about, that the court shall order removal to family court unless within 30 days the DA makes a motion to prevent removal. And the 30-day period can be told in the event that the kid fails to report to the probation department as directed. A motion to prevent removal of an action in the youth part shall be made in writing and upon prompt notice to the defendant. The motion shall contain allegations of sworn fact. The motion to prevent removal shall be made in writing within 30 days and upon prompt notice to the defendant. The motion shall contain allegations of sworn fact based upon personal knowledge of the affiant and shall indicate if the DA is requesting a hearing. The defendant shall be given prompt notice, and the motion shall be noticed to be heard promptly. So two promptly's in there and a 30 days so far. The defendant shall be given an opportunity to reply. He shall be granted any reasonable request for a delay. Either party may request a hearing on the facts alleged in the motion to prevent removal. The hearing shall be held expeditiously. So now we have 30 days, promptly, and expeditiously. The court shall deny the motion unless the court makes a determination upon such motion that extraordinary circumstances exist that prevent the transfer of the action to family court. The court shall deny the motion to prevent removal. The court shall deny the motion by the DA to prevent removal of the adolescent's case to family court unless extraordinary circumstances exist that should prevent the transfer. The court shall make a determination in writing or on the record within 5 days of the conclusion of the hearing or submission by the defendant, whichever occurs last. Such determination shall include findings of fact and, to the extent practicable, conclusions of law. For the purpose of this section, there shall be a presumption against custody, and case planning services shall be made available to the defendant. Notwithstanding any provision of this section, the Family Court Act shall apply to all actions transferred, provided, however, that such cases shall not be considered removals subject to sub 13 of section 308.1. Nothing in the subdivision shall preclude the court transferring the action where all parties agree or pursuant to this chapter. Oh my God, that flash makes a real difference. This is 722.23, section 2. Upon the arraignment of a defendant charged with a crime committed when he was 16 or in 2019-17 on a Class 8 felony other than a drug felony or a violent felony, the court shall schedule an appearance no later than 6 calendar days from such arraignment for the purpose of reviewing the accusatory instrument pursuant to the subdivision. The court shall notify the DA and defendant for the purpose of such appearance. Upon such appearance, the court shall review the accusatory instrument and any other relevant facts for the purpose of making a determination pursuant to paragraph C. Both parties may be heard and submit information relevant to this determination. C. The court shall order the action to proceed in accordance with sub 1, unless, after reviewing the papers, the court determines in writing that the DA had proved by a preponderance of the evidence one or more of the following set forth in the accusatory instrument. I, the defendant, caused significant physical injury to a person other than a participant in the crime, because they did not use the legal term of serious physical injury. They just said significant physical injury. Double I, the defendant displayed a firearm, rifle, shotgun, or deadly weapon in furtherance of such offense. Or triple I, the defendant unlawfully engaged in sexual intercourse, oral sexual conduct, anal sexual conduct, or sexual contact as defined in 130 of the penal law. So I think the key word there, just to notice, is it has to say unlawfully. It can't just say that they engaged in sexual contact. It has to say unlawful sexual contact, or he's an adolescent offender and he will go to the youth guard. But for our purposes, when I say that, it's because they only said that we have to know the laws that are in effect as of 2018, October 2018, and this law is in effect for 16-year-olds only in 2018.